So the Supreme Court just issued a 6-3 decision in a malicious prosecution case, which won't bode well for the prosecutors in the Kyle Rittenhouse case, or those prosecutors or administrators who go after people because of red flag laws. So let's talk about this. But real quick before we jump into this video, if you think the government needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. If you enjoy gun repair, ballistics, and learning about firearms, Sonoran Desert Institute might be a good option for you. To find out more about SDI, visit www.sdi.edu, or you can call the number on the screen. Thank you again, SDI, for sponsoring this video. So like I said in the intro, the Supreme Court issued a 6-3 decision this week that now makes it easier for individuals to sue police, prosecutors, and various administrators for malicious prosecution. This case decision likely perked up the ears of people like Kyle Rittenhouse and likely others who have fallen subject to states targeting them for exercising their Second Amendment rights, and maybe even people subject to red flag laws. Now you may be asking yourself at this point, what is malicious prosecution and why should I care about this and why would this impact the Second Amendment context? Generally, malicious prosecution is a claim seeking damages resulting from the institution or the continuation of criminal proceedings for improper purposes and without probable cause. Prior to this decision by the Supreme Court, lower courts were split on whether a claimant under a malicious prosecution lawsuit needed to show an affirmative indication of innocence. There has been dispute of whether a finding of innocence is needed to bring and win a claim, or if a prosecutor abandoning a case would be sufficient enough. Now let's talk about what happened in this particular case, and then I'll give you my thoughts on why Kyle Rittenhouse and his claims for malicious prosecution likely got stronger, and why maybe red flag laws could also be at risk because of this decision. So this case at issue and the case decided by the Supreme Court was the Thompson case. And really this started all because of a diaper rash. And I know that sounds ridiculous, but that's really what spun up this whole case. Larry Thompson was living with his then fiance and their newborn baby when his sister-in-law, who was apparently and by all accounts actually mentally ill, decided to call 911 on him, claiming that Mr. Thompson was abusing the baby. When EMT officers arrived, they were admitted to the apartment by the sister-in-law who called them, but Mr. Thompson was unaware of why the 911 individuals were called, why EMT was showing up, and he told them that, well, you must have the wrong address, and so sent them away. The EMT officers left, but then they returned later to the apartment with 4 New York City police officers. This time, Mr. Thompson answered the door and refused to admit these police officers unless they actually had a search warrant, which, of course, you should do. The police then decided to throw Mr. Thompson on the floor, handcuffed him, while the EMTs examined the baby. And while they were examining the baby, the only marks they found on the child at all was a diaper rash. Despite that, the baby was then taken to the hospital where the diaper rash was in fact diagnosed, and that was the only thing that the baby was suffering from. But while all that was happening, Mr. Thompson, however, was tossed into jail for 2 days and was charged with resisting arrest and obstructing governmental administration. The prosecutors in his case eventually would try to get him to agree to a plea deal, which would have his record essentially wiped clean, but Mr. Thompson refused to actually take a plea deal because he knew he did nothing wrong. After he denied the plea deal, the prosecutors in his case subsequently decided to drop all charges without any explanation, likely because they knew they had no case. After the charges against him were dropped, Mr. Thompson decided to sue them for malicious prosecution. But under the federal appeals court precedent in New York, Thompson had to prove his innocence and that his innocence had been affirmed. The courts claimed that the prosecutors dropping the charges without explanation was not enough. It was not an affirmation of his innocence. And it is this weird case and these weird facts that eventually made their way up to the Supreme Court. The decision of the Supreme Court was written by Justice Kavanaugh, who was joined by Amy Coney Barrett, Chief Justice Roberts, and the other liberal justices on the Supreme Court. Justice Alito dissented, and he was joined by Justice Gorsuch and Justice Thomas. The majority held that to demonstrate a favorable termination of a criminal prosecution for purposes of the Fourth Amendment claim under Section 1983 for malicious prosecution, a plaintiff need not show that the criminal prosecution ended with some affirmative indication of innocence. Instead, a plaintiff only needs to show that his prosecution ended without a conviction. The court therefore held Mr. Thompson had satisfied that requirement in his case. So essentially, the Supreme Court stated that all that someone needs to do to have a malicious prosecution claim proceed forward in a court is that the prosecution ended without a conviction, instead of it needing to end with a finding of innocence or an affirmation of innocence, which is very rare. Courts don't actually say, we find you innocent. They say you're not guilty, things like that. They don't actually affirm that you're innocent. Something like that very rarely happens and really makes it a very high bar under the old rules for someone to actually bring and proceed forward with a malicious prosecution claim. So how may this tie into red flag laws and maybe even into the Kyle Rittenhouse issue? Well, first, let's talk about red flag laws. As we all know, red flag laws are obviously wrought with Fourth Amendment issues. Often these type of laws allow any person at all, without any real evidence, to point you out and then have a police officer or local agents come to your home and seize your firearms and maybe even require you to do other things as well. Then after the fact, you go to an administrative proceeding, maybe to a courtroom, and they determine whether or not that seizure was appropriate. That sounds pretty similar to what this individual, Mr. Thompson, had to deal with his child and him being arrested, all based on a third-party unvalidated claim. So if someone is red flagged and they go through the process, the court may reach a final determination that there was no basis for the red flag against them. However, there also may be situations where the officers, administrators, or maybe even the court decide to abandon the proceedings against that individual because they say maybe there's not enough evidence and they just say, we're not going to reach a final determination. We're just going to completely drop the proceedings against you. Since the waters have now been muddied about the malicious prosecution Fourth Amendment issues, I could very much see people who are illegitimately red flagged bringing Fourth Amendment lawsuits, but also malicious prosecution claims, maybe against those officers, administrators, or others who are involved in the process. It could serve as a further deterrent against agencies who decide to use the red flag mechanisms very willy-nilly, especially now that people can bring malicious prosecution actions in 1983 lawsuits for violations of constitutional rights. Now let's talk about how this could actually help Kyle Rittenhouse in his specific situation. Well, as we also in his trial, the prosecutors in that case clearly were operating under a political agenda, and the evidence they used during the trial and that we all saw play out in the trial really wasn't even enough to, in my opinion, to bring a claim against him. A lot of people across the nation, other prosecutors, defense attorneys, tons of attorneys would say that this was a complete sham of a trial, that they should have never tried to proceed forward against a trial against him. And since the trial ended, many have said that maybe Kyle should go after the prosecutors for malicious prosecution, but that would be an uphill battle under the old rules, since his not guilty verdict would not have actually been an affirmation of innocence. He would have to have received something more than just that non-conviction. He would actually need maybe the prosecutors themselves to say, yes, we agree he's innocent. However, now with this new Supreme Court opinion, his innocence is affirmed by the non-conviction, and therefore he can proceed forward with a malicious prosecution against these individuals, including Binger, because they actually tried to prosecute him without any probable cause, any real basis. Now, obviously, it is still not a lock that Kyle would win a malicious prosecution claim against those prosecutors. Those prosecutors could bring other types of claims in like qualified immunity for protection and other things like that. But it at least opens the door for a case to proceed forward, where before it could be thrown out just because courts would say your not guilty verdict is not a good enough affirmation of innocence. So time will tell whether or not this decision will actually become a huge thorn in the side of red flag laws and maybe the prosecutors in the Kyle Rittenhouse case. So this is one of those ones that's really interesting. Like the dissent said, it could create a lot of confusion, but it could create a lot of confusion in a good way, and it can be kind of weaponized in a good way, not just in the Kyle Rittenhouse case, but maybe even in red flag like cases and issues as well. Now, again, is that a 100% lock? Am I saying that's absolutely going to happen? No, but I could see someone trying. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way information. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget to stay with Built Bar Arms Scholars and station where we maintain Arms Scholars.